Have you ever wondered what stops a trial from just, going completely off the rails? It's not only the judge and the lawyers. There's a really detailed rulebook. And today, we're zooming in on the rules for one of the most important players in the whole game, the witness. We're going to look at what they can do, where they have to be, and what happens when they don't play by the book.
It's a classic TV moment, right? The star witness is suddenly missing, and total chaos breaks out. Well, in the real world, the legal system has a very clear, very powerful way to make sure that doesn't happen. And it all kicks off with one fundamental idea.
So, before we get into the nitty-gritty of how you force a witness to come to court, we need to understand why the system wants them there in person so badly. See, it's not just about the words they're saying, it's about how they're saying them.
And here it is, Rule 53.01. This is pretty much the bedrock of all witness testimony. The default setting is live, in-person, spoken evidence. Why? Because it lets the judge or the jury actually see the witness, their body language, their tone of voice, if they're making eye contact. All of that stuff is part of figuring out if someone is credible. And you just don't get that from a piece of paper.
Okay, so if having a witness there in the flesh is the gold standard, how does the court actually make sure they show up? Well, this is where the law gets its teeth.
So, let me introduce you to the summons to witness. Don't let the word summons fool you. This is not a polite request. It's a legally binding order from the court. Once you've been served with one of these, showing up isn't really optional anymore.
And the process for getting one, laid out in Rule 53.04, is actually pretty straightforward. A lawyer grabs a blank, signed and sealed form from the court, they fill in all the details, and then, and this part is key, it has to be served personally on the witness. At the exact same time, they also have to pay or offer something called attendance money, which is just to cover basic stuff like travel expenses.
Now, what's really interesting here is how the tool you use changes depending on the witness's situation. If they're here in Ontario, that standard summons we just talked about works fine. But if they're in another province, you need something called an interprovincial subpoena. And what if the witness is actually in jail? Well, you need a specific court order under Rule 53.06 to get them brought to the trial. The system really does have a tool for every scenario.
So let's be super clear about this. Ignoring that summons comes with some pretty serious consequences. Rule 53.04 spells it out. If a witness is properly served, gets their attendance money, and still decides to be a no-show, a judge can issue a warrant. And yes, that means the police can be sent to arrest them and bring them straight to court.
Okay, so we've got our witness to the courthouse. Great. But the rules don't just stop at the front door. To make sure everything is fair, the court has some pretty strict procedures for managing how that testimony is actually heard.
I mean, think about it. This is a huge concern in any trial. If witnesses are just sitting in the courtroom all day, listening to what everyone else says, it could totally change their own memory of what happened, whether they mean to or not. So how do you stop that from happening?
The answer is a pretty clever court order for the exclusion of witnesses. Any lawyer in the case can ask for it, and a judge can then order all the witnesses to wait outside the courtroom. They get called in one by one to give their evidence, and once they're done, they usually can't go back in. It's a brilliant way the court tries to protect the integrity of each person's story.
And the rule is strict. I mean, really strict. It's not just about them not being in the room. This is a direct quote from Rule 52.06, and it says that no one, not the lawyers, not their client, nobody, is allowed to tell an excluded witness what was said inside while they were out. It's a complete information lockdown. But, of course, there are a couple of important exceptions. You can't exactly exclude the actual people involved, the plaintiff or the defendant, from their own trial. They have a right to be there. And you also can't kick out a key witness, like an expert, if the lawyer absolutely needs them there to help run the case. In those situations, a judge might just make them testify first, before anyone else.
All right, now we get to one of the most strategic and, let's be honest, sometimes dramatic moves a lawyer can make in a trial. What if the best person to prove your case is the very person you're suing?
The rules have a specific name for this: an adverse party. Basically, this is anyone on the other side of the versus in the case name. And there's a special rule just for putting them on the witness stand.
So check out this comparison. Normally, when you call your own witness, you can't ask them leading questions. But Rule 53.07 completely flips the script. If you call an adverse party to the stand, you get to jump straight into cross-examination. This is huge. It lets you control the story, challenge them, and ask all those pointed yes or no questions right from the get-go. It's a really powerful way to lock an opponent into their version of the story. So remember how we started with that golden rule that testimony has to be live and in person? Well, like any good rulebook, this one has some pretty important exceptions.
And this is where something called affidavit evidence comes into play. An affidavit is just a written statement, but it's sworn under oath to be true. And in some very specific situations outlined in Rule 5302, this piece of paper can actually be used instead of having the person testify live.
But hold on, you can't just decide to use an affidavit because it's easier. You need the court's permission. And here is the most important check and balance. If the other side has a good reason to want to cross-examine that person, the affidavit probably won't be allowed. The right to challenge evidence is that important. A judge always has the final say and can insist, nope, I need to see this person testify in my courtroom.
And all this brings us to a final, really big question. This whole idea of watching a witness in open court, it comes from a time way before video calls and digital evidence. It's a system built on the belief that being there in person is the best way to judge credibility. But in a world where so much of how we communicate is remote, are these old rules still the best way to get to the truth? Or is it maybe time we rethink what it really means to witness testimony?